Hi, Attorney Ummi here. Thank you so much for tuning in. So today I want to talk a little bit about probate. Now, before we dive into the 5 probate myths that will surprise you, I want to take a moment and just explain what probate is in simple terms. So, probate is the process that people go through when they lose their loved ones to get a judge to approve how the assets of the deceased person would be distributed. Mind you, distribution includes paying off any debts and unpaid taxes. So basically, if you die, for example, today, all of your bank accounts will be frozen and your loved ones cannot access it until a judge gives an approval. Now, unless you have some sort of estate planning, then in that case, your loved ones could access it. So there are basically 2 ways that you can start a probate process. The one way is when there is a will, and the other way is when there is no will. So let's start with this more like a straightforward one. When there is no will, basically a loved one has to file a petition with the probate court to start the process of probate for that person that passed away. When there is a will, there are 2 ways you can do it, at least in Texas. You can either do immuniment of title or you can do letters testamentary. Now, let's not get caught up with all the legal terms here. It simply means that when it's immuniment of title, the person does not have a big estate and does not have any debt whatsoever. When it's a letters testamentary, on the other hand, the person has a much bigger estate and some debt that needs to go through the probate process. Now, there's so many other requirements for each of these processes that are way beyond this video. Now, let's dive into the top 5 myths about probate that will surprise you. The first one I want to talk about is you don't have to go through probate when you have a will. Now, the truth is, as we've seen from my introduction about what probate is, a will does not keep you out of probate. You still have to either file immuniment of title or letters testamentary, right? So, just creating a will is super important because a will is a very, very important document. However, you still have to file that will with the probate court to administer the estate. Now, administering the estate simply means putting that will into action. The second myth is that it is easy to probate your estate by yourself. Now, I get it. I am a DIY person myself. Unfortunately, it could actually be an unauthorized practice of law if you're gonna probate your estate by yourself, because it requires a lot of pleadings to be drafted and filed with the court, and only an attorney can do that. Now, you also want to make sure that everything is done properly. So if you've never probated an estate, why on earth would you do it yourself? The third myth I want to talk about is your spouse gets everything when you go through probate. Now, in some situations this is true, but in most cases it is not. And I've talked about this in one of my videos, Estate Planning Explained. You can watch it. But basically, a marriage certificate is not a ticket to your spouse getting everything when you pass away. And I'll give you an example. A client of mine who lost her husband and is now being forced to pay her stepkids a share of what they own in their home, the house that she built with the husband. And even though the husband didn't want the kids to get anything because they're well off and they don't need that money, but because they're entitled to it, she's having to pay them that money right now for a house that they built together with her husband. Myth number 4 is that it is easier to go through probate than to pay an attorney to create an estate plan. Now, probate comes with a lot of disadvantages, like having to wait for months before your loved ones can get access to what you leave behind. Meanwhile, they could have access to everything immediately if you had an estate plan, and they wouldn't have to pay for the funeral expenses out of their pocket or start a GoFundMe page for you. Another disadvantage is that you will have to deal with the court system, and we all know how things go when they move at the speed of the government. You also would likely have to pay an attorney an hourly fee to go through probate because there is a lot of uncertainty when going through probate. You could have paid an attorney to create an estate plan for a fixed fee that is almost always a fraction of what it will end up costing you to go through probate. Myth number 5. Probate is only for large estates. Now, while you can save money when you have a small estate, especially if you have a will and you file a muniment of title, the truth is people with small estates tend to come from an unstable family dynamic, which means that there is higher likelihood of conflict arising. The biggest reason why probate gets messy is because there is conflict among the heirs. I hope you found this video helpful. Now, if there's anything you would like for me to talk about, please leave it in the comment. Also, let me know what you think about this video. And tune in every Wednesday for another video on building generational wealth, explaining the law in plain English, and talking about how to legally protect yourself and your business.